Hello, friends. Welcome to Investment Immigration Conversations. I'm Carolyn Lee, principal and founder of Carolyn Lee Pllc, a U.S. investment immigration firm dedicated to helping clients build their futures with investment immigration. So welcome to today's webcast. We've been rolling out with these regularly, even if they're short, just to stay in touch with our community and trying to keep folks updated on the many happenings in investment immigration, particularly, of course, in the EB-5 space, with the passage of the EB-5 Reform and Integrity Act of 2022, or RIA, or RIA. I realized that after we've sent out our postings about this event, that perhaps we were promising to take on a much bigger, more comprehensive topic of EB-5 writ large, or EB-5 basics under RIA. And perhaps we should have one of those. But my goals are really more modest for today. I would like to talk about the basics, yes, the EB-5 basic experience through a couple of client stories. Real clients, in some instances, facts are an amalgam of a number of different clients to highlight a point. Because I think that sometimes hearing information told through stories can kind of make the information come to life a little bit more, rather than dryly reciting the requirements yet again, which I feel like I must have done many times. And the requirements indeed are really quite basic, and the basics at that very high level haven't changed under the RIA. The basics are really about two things: investment and job creation. And there's also a fairly straightforward allocation of the division of labor in terms of who is responsible for the investment portion and who's responsible for the job creation portion. Of course, it's all tied. The party primarily responsible for the investment-related evidence is the investor, the individual investor, or the petitioner, the EB-5 investor. And the party primarily responsible for proving the job creation of 10 full-time U.S. jobs per investor falls with the new commercial enterprise, the business into which the investor contributes his or her EB-5 capital. And in the regional center investment context, the second part of that equation, the job creation, new commercial enterprise portion of the filing of an EB-5 investor filing, will be taken up by the regional center or the project managers who have arranged that EB-5 deal. So very basic at the very high level. And of course, there's a lot more complexity, layers and layers beneath those basics at that very high level. I thought I would start with what might be the juiciest bits first and try to distill those down too. These are the post-RIA changes to the EB-5 framework that I think are really big. The first, I think, is, of course, the integrity measures, right? We're in a very different space in terms of the required oversight, the required administrative responsibilities of operating a EB-5 regional center under RIA. Goes without saying, perhaps. We are looking at a universe of concurrent filings. Oh my gosh, this is huge. And this brings EB-5 as an employment-based immigrant visa category in line with the other employment-based green card categories, in that if there's visa availability, meaning no backlog, then an EB-5 investor who is otherwise adjustable, who may adjust, who's here in the United States in valid non-immigrant status, can concurrently file for adjustment of status rather than needing to wait until after that 526 petition is approved. Source of funds. Source of funds standards themselves have not changed all that much. However, we now need to source the admin fees and costs associated with the investment. So that means it's 800,000 at the TEA level or 1.05 million at the non-TEA level, plus admin fees and costs associated with that investment. And here's where the difficulty I'm finding in our practice is, in the world of 500K and 1 million, it was very clear where to stop with the sourcing and the tracing of the path of funds. It's at the 500,000 level. Now it's more open-ended because we don't yet know exactly what USCIS, what the statute demands by way of additional administrative costs and fees on top of that. Could it include travel costs as an example? Certainly the administrative fee that a regional center charges, but what else in addition to that? We don't know. And so that makes the inquiry as to how much to source and trace a bit more open-ended. So I think that's a mentionable change. And of course, the new set-asides. And these are big questions associated with how the State Department, how USCIS are going to interpret and implement these set-asides that promise to create a remedy for the backlog in the unreserved category, because these are separate queues. But we won't know, we probably won't know how the interpretation and the implementation are actually going to be executed for another couple of years. Because at least under the current interpretation or the seeming interpretation of the State Department in implementing the set-asides, they will be allocated to investors investing post-RIA. And so investors investing post-RIA, filing their I-526s and I-526s 6Es post-RIA will not be tested in terms of which pot their cases will go to until a couple of years down the road, when their I-526s get processed and they're in queue for immigrant visa issuance. So that all said, how about a couple of stories just to see how these rules will play out? So if you're a new prospective EB-5 investor seriously considering this route for US immigration, I would imagine you have questions about how other investors' experiences have gone. And of course, there is a book in each investor's immigration story. So these are just really snippets of just a couple. So let's start with a direct EB-5 investor, shall we? So this investor story is one that starts with an E2 visa, British family, British investor, and E-visas for a long time, successful residential real estate development business in Florida, doing very, very well. and are leveraging their E2 based revenues into an EB-5 direct investment based on this growing enterprise that they have. 5 full-time US employees at the start of the voyage, and very confident, no problem. We'll have additional 5 employees within the time period, within the next couple of years, and be able to comfortably file the 829. 526 approved, no problem. Consulate processed in London, large family, great. Came in, begin their conditional permanent residency. About 2 years later, they're now coming up for their I-829 petition filing to remove the conditions. Well, what had happened? The Great Recession and the real estate bust. And so this business that a few years ago was jamming, now not doing as well. And in fact, after having reached the pinnacle of 9 full-time employees, are now down to 7. What to do? 829 window is a hard window, must file the 829 within the 90-day window of the 2-year anniversary of becoming a conditional permanent resident. So this is where we roll up our sleeves and dig into the facts with the client. And the happy and short ending to this story is that we were able to successfully argue that the jobs will be created within a reasonable period of time. The additional 3 jobs will be created within a reasonable period of time. And the 829 was eventually approved after showing the trajectory of job growth, the macroeconomic factors behind why those jobs were not all there, showing that they were nearly there, and so forth. Really painting that narrative out in the case. And that case, again, was successful and the 829 approved, conditions lifted. What are some of the takeaways there? It's hard to know at the start of this long journey how things are going to play out. There is that element of uncertainty. And in fact, the at-risk nature of the investment is cooked right into the requirements of this visa. In the United States, the investment visa requires an at-risk investment. And lots of things can happen. It's a business, it's an investment. And there can be factors related to the particular business as such, or there could be macro factors on top of it, like the pandemic, like the Great Recession of 2008. But also that there can be solutions, maybe not in all instances, but the solutions, the availability of solutions must be investigated if one finds oneself in that thorny spot, and that that there may be viable solutions to those sticky spots right in our laws, nowhere else. I think that's where we can leave things there. Second investor, Indian anesthesiologist, long training, so specialty specializations in medicine, the whole thing, J1 residency, H1B, number of years, I-140 approved, terrible backlog in the EB2. So EB-5 makes sense to explore seriously. So the anesthesiologist supplements her well-documented W-2 US-based 1040 supported income with a gift from another family member, a cardiologist practicing in New Jersey, wonderful practice, and a gift from parents in India. And the source in India, the parent source, came from sale of stock, sale of some real property, retirement savings over time. So that part of it Complicated, took time to do, got there. 3 streams of source of funds put together, filed. While the case is still pending, because under current processing times and in real life, these 526s take a few years, RIA passes, now we have concurrent filing. Client she's in valid H-1B status, extended under AC 21 beyond the 6 years, and so can concurrently file the adjustment of status application, even though she couldn't as an EB-2 I-140 beneficiary because the EB-2 categories wasn't current. So concurrently file the adjustment of status application in May of 2022, get the EAD, and she's got that going. Then retrogression applicable to Indian investors announced in the October 2022 visa bulletin. Her priority date comes after the visa cutoff date under Chart B for adjustment of status applicants, which is 2019. So if she were filing now, October 5th, she would not have the ability to file that concurrent adjustment of status application with the EAD and the advance parole associated with it. However, she filed her adjustment right when she could, and now she has the EAD, even though she is retrogressed in the unreserved category. So what's the takeaway here? It's fluid. There's a lot happening, even for investors who filed pre-RIA. So the way that I picture writing EB-5 is there's a lot of concentration and planning and careful preparation of the investor, the family, the case. At the start of the case, there's a lot. It's like, when you see, I don't surf, but when you see them, seems like there's a lot of concentration involved and balancing to get on that board, maybe stay on that board, and to find where in the wave they want to be, to have that ride. And that's the image that came to me as I was thinking about this. There is that concentrated effort to get on a path where you can sort of ride the wave at least for some time. Okay, and then if that's done well, you do ride that wave for a while. You coast. And then something comes up. It's like I envision, maybe, I don't know, maybe the wave shifts, something changes and you've got to adjust to it. And you must. Perhaps there's an RFE on the source of funds. Perhaps there's an RFE on the project. And there's that moment of concentration again, where you're dealing with what's happened that affects the case. And then the payoff of that concentrated effort is there is another round of reprieve, because now you're, riding that wave again until the next thing. And I think one of the most instructive things to understand, and I'll try to remember to include a link to this and maybe post to our website, is the timeline, is the journey, the voyage. It's not something that has a start and finish in a matter of months. It's something that has a start and finish in a matter of a number of years, with multiple steps, with adjustments that need to be made along the way, almost all the time. So I think as a prospective investor coming into the EB-5 investment process, one of the best things that one can do is to have an understanding of that timeline, of the processes involved: 526 filing, 526 approval, consular processing, or concurrent adjustment of status filing, entry into the United States or admission into the United States and conditional permanent residency status, day 1 of CPR status, 2 years of conditional permanent residency, 90-day window before in which to file the IA-29 petition. Petition filed, petition pending, petition approved. That's the end of the EB-5 journey. So, third example, investors, multiple investors in the same EB-5 regional center-based project, Chinese investors. They've been doing this for a while. They've been in it for a while. Maturity has reached on the underlying first EB-5 loan. And there's been a proposal for redeploying that capital. And this has caused concern, mostly arising from a lack of understanding what's going on. Is this a good thing that's happening, or is it not a good thing? How to analyze the situation applicable to the investor. And these are investors all in different places in their immigration. Some at 526 is pending, some at 526 is approved. Some are further along in the immigrant visa application process with the NVC, and so forth. So how to analyze the situation? Well, we're engaged to help the investors understand, and there's a deadline for consenting to the redeployment deal. So again, the question is how to understand what's happened, the redeployment context, and the RIA gloss to it. First of all, when I analyze a situation like this, first thing I look at, what's the status of the initial project? Okay, we know that the loan's been repaid. What else is going on? Has the thing been built? Is the project complete? Per the business plan, have the jobs been created? So it involves an analysis of the underlying project, the initial case. And then the redeployment analysis based on the guidance that we have. We have like a 33-point checklist for redeployment analysis. It is pretty granular, but you go through that analysis based on the policy guidance that we have. And the RIA gloss that we now have on top of that, which has questions which for the most part are I think deemed beneficial, because it answers the question as to whether or not a regional center may redeploy outside the original regional center geography. Policy, USCIS policy had said no. The statute says yes. But there is another question that has arisen, which is, what is the duration, required duration of the investment? And there is some discussion out there about whether or not it's only 2 years, or whether it's the sustainment period as defined currently in the policy manual, which is the 2 years of conditional residency. So for Chinese investors who are in the backlog, who have not yet come into their conditional residency because there's not yet visa availability, there's a real question. Is my sustainment period, is the period for which I've got to have the capital out there and not repaid to me, is that shorter than the end of the 2 years in conditional permanent residency status. I will say here that that my current interpretation is that the sustainment period is as it is in the policy. For now, until we get, or unless we get different guidance, that it ends at the end of the 2 years in conditional permanent residency. Could very well be proven wrong, but I think that it's probably quite aggressive to view the investment period as being just 2 years from the time of the initial investment, and therefore the capital can be returned after 2 years. So what's the takeaway in that scenario? Is that the most important thing is having good information upon which one feels confident. And I do think that it's, you know it when you have it, when you know it when you see it. And that allows one to feel much more connected to the events, as opposed to feeling out of control or concern about things happening that maybe they don't understand. Maybe an investor doesn't understand quite reasonably, because it's difficult to understand. So I hope that's been helpful, and we welcome feedback. So please feel free to provide us with feedback. Contact at Carolyn Lee Pllc, and we look forward to engaging with our audience, our community on this channel. Take care. Be well.